Thank you, Mr. Chairman. Ms. Gilligan, in your testimony, you talk about something that I'd just like to have explained better, is having to do with airworthiness directives. Whereas when we promulgate an airworthiness directive, most other aviation authorities apparently forward that to operators and they abide by it. But it seems from the testimony that it can't work the other way. That is, if EASA, has one, we can't adopt it. Why is that?
Yes, sir. The requirements that we have for rulemaking, legislative requirements for rulemaking, require that the agency make its own finding, in essence, that in fact there is a safety issue. We do find that at times it's somewhat redundant because, again, we rely on many of our partners for the original certification of the product. We validate that. We expect them to be responsible for the continued operational safety, and yet we have to go through a process of notice and comment before we can put in place the directive that they may have put in place for their product in other states. We have talked with staff to see if there might be something that would be helpful. And in fact, in the bill that was worked on last year, there was some language that we think would be helpful, and we'll certainly look to work with you again to try to support that.
So, I mean, the net result is that, although I assume that many operators might go ahead and comply with it once they become aware of it, but it's not mandatory because we haven't been able to adopt a rule.
That's correct. We can't enforce it.
All right.
We do, of course, see that many operators implement it. They are sometimes hesitant because it's not inconceivable when we go through our process, we might have some nuanced change or something that we find necessary. But generally, they will follow what they learn from the manufacturer directly. And that's why we were looking to see if there might be some way we can streamline that process. But the Administrative Procedures Act right now is a piece of the puzzle that we're struggling with.
And then the issue I raised about the European Authority and the charges they levy to essentially rubber stamp what the FAA has already done. Have there been discussions with the authority regarding that?
Yes, sir, extensive discussions. We actually did get a small reduction shortly after we entered our bilateral agreement that oversees how we relate to EASA. We are close, I believe, to getting an agreement on how we will further reduce the fees on large projects. But as I testified, we do already have agreement with the European Aviation Safety Agency that there are certain approvals that we give that they will simply accept. So there will be no work for them to do and there will be no charge, and that has already been put in place. There are some other approvals that need some administrative work for which there will be minimal fees, and that has already been put in place. Now we're taking on the larger, more complex projects to reach agreement as to how we will reduce the time we spend and that they spend on projects and thereby reduce their fees. So I hope to have some real progress on that, if not before I leave, not long after.
Okay, thank you. Thank you, Mr. Chairman.
Thank you.